I want to go now to former federal prosecutor Neama Rahmani for more on this. So look, Neama, you just heard the judge rejected the defense's play here. Does that mean now it's over and done? The death penalty will be in play throughout this trial? And how does that change the defense's arguments at all?
Okay, now this was an argument as much for the trial court as it was for the appellate court. I thought there was no possibility the judge was going to take the death penalty off the table, but if you're a death penalty lawyer, your goal is not to get a not guilty verdict necessarily, but to save Bryan Kohberger's life. And we know that in death penalty cases, there are mandatory state and federal appeals. So if they don't raise these challenges at the trial court level, they're waived on appeal or waived for a habeas petition. So they took a kitchen sink approach. They threw everything out there, Fifth Amendment, Sixth Amendment, Eighth Amendment, 14th Amendment, saying that his rights were violated. The judge properly denied those arguments. So we're going to move forward, hopefully in 2025.
And you're right. It's almost like they're laying the groundwork here for future arguments down the line should he possibly be convicted. And one of the arguments that came up in court was really unique and sort of specific to Idaho, although there's a few other states as well that offer execution by firing squad if lethal injection drugs are not available. And his lead defense attorney, Ann Taylor, essentially argued that it is really hard for a client to be sitting on death row, perhaps not even knowing how they might be executed. What do you make of that argument?
Well, Ann Taylor is one of the best and one of the few death penalty qualified lawyers there in Idaho, but the Supreme Court has rejected this argument, and it's really a fallback. And like you said, one of the arguments is that lethal injection and the firing squad, they both violate the Constitution's prohibition on cruel and unusual punishment. And we have seen occasions where the cocktail dose in a lethal injection case has not worked. The execution has had to be rescheduled. There are some pharmaceutical companies and drug makers that don't want their drugs used for the death penalty and for execution. So it's really a fallback. But again, I don't think the argument is going to work. The Supreme Court has squarely rejected this argument. They've also argued that the death penalty violates his right to a speedy trial because they need to spend more time preparing, that the trial shouldn't be bifurcated, that there should actually be 3 different proceedings, first a guilt phase, then whether there's aggravating factors, and then whether the aggravating factors outweigh the mitigating factors. They try to strike different elements of the death penalty, those aggravating factors, saying that they're having more than one murder doesn't necessarily make someone qualified for the death penalty, or that the murders here were not particularly cruel, heinous. They didn't show a disregard for human life. Again, not good arguments. These are probably, if not the worst, one of the worst murders in Idaho state history. So the judge summarily denied the arguments in a very well thought out written opinion that's going to withstand appeal.
I want to ask you about some other filings here from Bryan Kohberger's defense team. They made a sweeping challenge that really centers around the investigative genetic genealogy that they used to even pinpoint Kohberger in the first place. And essentially, Taylor is making this argument here that if you throw that out, everything that was gathered afterwards has to go as well. I mean, this is really the crux of the case. What do you think about that argument?
Well, this is really a fascinating argument, and we're seeing it more and more. And this is the argument. Bryan Kohberger was identified not because of his DNA, because law enforcement didn't have his DNA, but because of his father's DNA. And these familial matches, they are somewhat controversial. One of us may have a relative who's been booked, arrested, and that may identify us, or, potentially giving their DNA to some third party. But here, it's pretty well established that Kohberger's father, when he tossed out food and drinks, and there's no real Fourth Amendment expectation of privacy in your trash. So the father's DNA is fair game. Then the question is, can law enforcement use that to connect the DNA to someone like Bryan Kohberger? As a former prosecutor, I think it is. But this is a newer area of the law. Hasn't really been litigated that aggressively. And the few courts that have addressed it said that it is okay and it's fair game. But this is something I expect folks like Taylor, Kohberger's defense team, to attack aggressively when it comes to the defense bar.
Right, and a reminder that law enforcement says they tied Bryan Kohberger to the crime using DNA that was found on the button snap of a knife sheath that was found underneath Madison Mogen. She was killed along with her best friend Kaylee Gonzalez and Xana Kernodle and Ethan Chapin. Again, that trial is set to start in August. Neama Rahmani, thank you for being here with us today.